Let's get some analysis now from the UJ Law Clinic's Elton Hart. A very good afternoon and welcome to Today, Elton. What should we make of the statement that the President has just released welcoming the court's decision?
Now, obviously, for me, from the get-go, I know that this application or the nollie prosecute that was brought by the former president against our current president was not good in law, because there's no duty on our president to actually interfere with judicial matters, because there's the separation of powers principle. The president is the head of the executive, then you've got your judiciary and you've got your legislature. So now, who decides on nollie prosecute certificates? It's the NPA, and specifically Ms. Shamila Batoy's office is responsible for that, and also the delegated powers to the different DDPs of the different provinces. So for him complaining to the president that the NPA or an employee of the NPA has sort of disseminated this private personal information is not something that the president should entertain, should be interfering. That should be directed to the Director of Public Prosecution's office, Ms. Shamila Batoy. And that, for me, was the problem already with the president's private prosecution of the current president, the former president, with his former president's current private prosecution of the current president. So that was the problem for me there. And also the certificate that was issued does not mention the current president's name. So that also, it's like it's open, it's vague, and it's not specific. That certificate needs to specify who the people is that that certificate pertains to. So for me, the former president's private prosecution and summons that was subsequently issued was then unlawful, and it violated the current president's constitutional rights.
And Elton, in as far as process is concerned, was the former president perhaps ill-advised to go this route of pursuing the president in this manner?
For me, it was ill-advised, because I just see a lot of politicking in the way that thing was handled, and I think he should have known better, because we know that the president is not supposed to interfere and meddle within the business of the National Prosecuting Authority. Although he appoints the National Director of Public Prosecution, but that's as far as his power stretches. What cases they decide to prosecute, he should not be interfering into those ones. And especially here, it was now where a former president comes to him. He was supposed to go to the police station, lay a complaint in the jurisdiction where it was, and most probably it would be somewhere in the Pietermaritzburg area where he would have laid the complaint, and then take it from there, and not sort of half sidetracked and went back. But yeah, I see a lot of politics in how this thing went about and how it actually landed up on the desk of the three judges, the full bench of the Pietermaritzburg High Court.
And Elton, speaking of that political grandstanding, is this the last we are now hearing of this matter, or does the former president have other means that he can explore?
Obviously, by the rate that our former president is going, he's appealed everything that was given, that he was aggrieved by. So he appealed. And obviously, we should not eliminate that option, because he can, because it was the full bench of the Pietermaritzburg High Court that actually said that this certificate is unlawful and unconstitutional. So he has the right, and remember, I'm not saying he is right. He's got the right to actually go to the Supreme Court of Appeal in Bloemfontein and say, listen, yeah, I think the full bench in Pietermaritzburg misdirected themselves in applying the law. I think you guys will come to a different conclusion. And then they can look at the matter and decide, is there merits to his argument or not? And if they also decide in favor of the current sitting president, he can then go to the Constitutional Court and actually say, Constitutional Court, this is a matter of constitution, or there's a constitutional aspect to this matter. Please, you guys now look at it. And that is not, for me, I think he might be going that route, but it will be ill-advised if he goes that route. I would say, listen, yeah, leave it, and rather focus your application for private prosecution on Advocate Billy Downer, as well as Karen Moore in this instance, that you say that the information that was given, it was unlawfully given to the journalist. And that might be your better bet. But going after the president, I think if somebody tells him to do that, it will be bad and ill-advised.
And in as far as the journalist and Billy Downer are concerned, Elton, what recourse do they have, if any?
No, obviously, they can also approach court and say, okay, the certificates that was issued is unlawful, unconstitutional because it was unlawfully issued and it shouldn't have been issued and it violates their constitutional rights. But one needs to now look at, because the argument that Balidowner was putting on the table is to say that this was a public document. So one needs to go and investigate, was this document freely available to the public? Although we know if you disclose information to the NPA when its litigation process is ongoing, when it comes to discovery, documents are discovered between the parties, and then a document becomes public. But sometimes certain documents is covered by privilege and confidentiality. And if in the discovery process it was said, this was only given to you guys so that you guys can see that I was not medically fit to actually stand trial at that point in time and should not be disclosed or used for any other purpose than what it was disclosed for, then we're sitting in another ballgame. And then Karen Mon has to come and answer as to how she got hold and wind of that document. So there is, you can argue both sides, but obviously for the former president, he will say, this I disclosed it only to show to court that I was ill at the time and I could not stand trial. And that was the only purpose why it should have been used for. It was not supposed to be used for anything else other than that, to get that postponement to say, I'm not ready to stand trial. I did not give consent so that it be disclosed to anybody, so they were not at liberty to disclose this document. If they wanted to disclose it, they had to get his consent. On the other side, they can say, but okay, we did not get it from the NPA, we got it from other sources, maybe because we also know that journalists is protected to a certain extent pertaining to their sources. So they can then come with that angle, but that's something that the court needs to ventilate to see, was there something unlawful in actually distributing and disseminating that information pertaining to his private and confidential medical affairs.
And would at any point the doctors in question who put together this medical report come into, would their integrity be questioned at all, Elton, do you think?
No, it depends on what they say in the report. Obviously, if they say that these doctors were lying, then it means that you had to subject the former president to a medical examination, which we know never took place. It was only the military one hospital's doctors that looked at him and said that he was not medically fit to stand trial. So you would have had to have another doctor to say, listen, yeah, this man was also evaluated by me and he is actually fit to stand trial. You cannot just look at a medical report and say this is not a good enough reason because you haven't seen, you did not have the guy on the table. So there is these pros and cons in the process, but I don't think the integrity of the doctors will become in question. But obviously, in the minds of politicians, they would most probably say that there is something questionable about the doctors at M1 Hospital.
That was UJ Law Clinic's Elton Hart. Thank you so much for that clarity this afternoon.